Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk, the most fact-driven, unbiased true crime channel on the entire internet. We have a good docket today for you. So first, we're going to follow up a little bit on the order that was issued in the Lori Vallow matter yesterday. Further explain that. Second, a romantic evening almost turns deadly. Wait till you hear this story. Third, let's talk double jeopardy. Fourth, a mother dies trying to save her baby. Fifth, who has your credit card number? And finally, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Crime Talk, and my name is Scott Reisch. Thanks for watching. If you haven't done so already, please hit that subscribe button as well as that little bell so that you receive notifications of when we go live or put up new content. First on the docket today, a little follow-up regarding our little bonus video that we put up regarding the order in the Lori Vallow matter. Now, I got kind of a little bit of a frustration with the Idaho case information data that they make available. This order came out yesterday, but it didn't have the motion that was actually filed. Now, we can glean from the motion that Mark Means filed on behalf of Lori Vallow that it was a very generic motion, as the court said that Mr. Means only filed a very brief statement basically asking the court to reconsider the denial of removing Mr. Wood as the special prosecutor in Lori Vallow and Chad Daybell's case. The court said in this motion, the motion cites the Idaho State Constitution, the United States Constitution, and any other applicable rule of law. Well, normally the attorney's job is to provide the authority that the court is going to rely upon to change their decision. Now, are motions to reconsider filed on occasion? Certainly they are. But what is the key ingredient when you file a motion to reconsider? You have to have new information that really wasn't available at the time of the hearing or at the time that the court ruled. And therefore, you're saying, Judge, we'd ask for you to reconsider the motion in light of this new evidence that we have brought forth, or the proffer that we are making, that we would bring this evidence forward. When you say any other applicable law, what the hell is that? That is just a Hail Mary, so to speak, like, Judge, help me out here. I'm not really sure why Mr. Means filed a motion to reconsider other than he thinks the court is wrong. Welcome to the world of criminal defense. Welcome to the world of criminal defense when you lose nearly every motion filed. Why is that? The law is written in favor of the prosecution, and you simply don't get to go back and rehash it. You've made your motion, you've had your hearing, you lost. You can certainly raise that issue on appeal if it comes to that, and because the issue is preserved. Filing a motion to reconsider is frankly a waste of your time, the attorney's time, the client's money, and frankly, a waste of the court's time. Clearly, the court didn't spend a whole lot of time on Mr. Means' order yesterday, as it's literally less than half a page, and basically it says there's no basis in the law for me to even grant the relief that you are requesting. I do not know what Mr. Means expected the court to do, but usually it's the attorney's job to say, court, here is the law that gives you the authority to do what we're asking to do. You're not going out on a limb. I just don't understand it. We'll try to give Mr. Means a fair shake. We've actually said that we've agreed with him on a few things, but I just really don't understand what he is doing in this particular case. All right, enough of Lori Vallow and Mr. Means for today. Next on the docket, a romantic evening almost turns deadly. Wait till you hear the facts of this case. This is a case in Alabama. So an Alabama man is being charged with the attempted murder and a domestic violence factual basis following an incident that took place. Apparently, the documents that we've reviewed painted a very disturbing picture between Mr. Kyle Waters and his wife after the couple went out to dinner together. Now, according to these court documents, Waters and his wife were intimate after dinner while in the loft area of a storage building behind their home. And then something happened. It's then alleged that Mr. Waters pushes his wife from the loft while she's looking over the ledge. She falls some 8 feet to the ground, lands on the cement. But wait, there's more. That's right. Mr. Waters then jumps on his wife and began banging her head on the floor. Then he attempts to stab her with glass shards that are strewn about. And wait, it gets even better. He then tries to go after her with a saw to cut her throat. Yes, craziness. All true. I'm sure you can imagine that there was an excessive amount of blood at the scene as a result of the saw. Investigators did find blood-covered glass shards at the scene, as well as the saw. Now, the victim was taken to the hospital and she's expected to survive, thank goodness. There's no motive, and Mrs. Waters was unable to explain what happened as to why Mr. Waters allegedly did what he did. He's behind bars. He has a preliminary hearing coming up on February 24th, and maybe at that hearing, more information will come out as to why he grabbed the circular saw to allegedly cut his wife's throat. And take a look at this guy. I mean, what does somebody look like that's going to kill their spouse look like? You can never say for sure, right? Crazy case, crazy case. Fortunately, Mrs. Waters is okay. I'm sure she'll be filing for divorce soon. I hope she does. Next on the docket, let's talk double jeopardy. All right, the Fifth Amendment of the United States Constitution provides many protections to all citizens. And it states rather clearly, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Well, the double jeopardy clause states, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Pretty straightforward. And a lot of people would think, well, it just means you can't be tried for the same crime twice. Pretty straightforward. That's what it's supposed to mean. But as I have said this before, when has a prosecutor ever said, you know what, I think we need to be restrained here according to the Constitution because these limits put on us are there for reasonable purposes. But no, what does the government always do? Try to get around limitations put on them. Well, there was a case that went to trial a couple years ago down in Louisiana. And it was a case regarding a defendant by the name of Ronald Gasser. And he was accused of killing kind of a local hero who went to play on several NFL teams by the name of Joe McKnight. Well, Gasser had faced a murder charge in his first trial in 2018, but a jury convicted him of manslaughter, which is a lesser charge than the murder charge, on a 10-2 vote. You may recall that we talked about the Supreme Court case where it held that the only two jurisdictions that still had non-unanimous juries for criminal cases were Louisiana and Oregon. Well, in this particular case, the jury came back 10-2 for manslaughter. Gasser wanted a new trial after the United States Supreme Court ruled that non-unanimous jury verdicts were unconstitutional. So the district attorney in this particular case said, hey, fine, we'll give you a new trial, but guess what? We're going to charge you on the previous crime of second-degree murder that you were acquitted of, because we're going to do a do-over. Now, I don't know where this district attorney got his law license, but this is literally first year law kind of analysis and rationale. So needless to say, the defense in this particular case said, no way. The fact that he was found not guilty at the trial of second-degree homicide, he is acquitted of that. He wants a new trial only on the manslaughter charge. Well, guess what? The judge agreed. It just makes common sense. That's been the rule of law for at least what I've always known, and I've never heard of any exceptions to it. Everybody knows if you're acquitted of the greater charges and you're found guilty of a lesser charge and you appeal and you get a new trial, you get a new trial only on the lesser charges that there was a conviction for. It's that simple. Additionally, if you've been sentenced and you go up and it gets reversed, the sentence can't be any greater the second time around than it was the first time. So fortunately, the court in this particular case, the trial court, ruled in favor of the defendant. Hopefully, the prosecuting attorney will go read up on some law, some plain meaning of the law as it relates to double jeopardy. Very shocking. It should be, but it never is. Prosecutors, I've said this before, nobody in the government gets up and says, hey, let's limit our power today. Let's dismiss cases because I think the search was unreasonable. No, they'll always defend it, saying everything that they did was reasonable and try to expand their authority, which goes against the limitations put in the United States Constitution and the amendments thereto, specifically the Bill of Rights. All right, a very sad case. Next on the docket, a mother dies attempting to save her child. Listen to this. Police in Arizona have apprehended a guy by the name of Eric Mays. He's the father of the child that he's being accused of kidnapping. His son was 10 months old at the time, and the child was in the boy's mother's car while she was loading him into the car in the baby seat. The mother, 30-year-old Brittany Walker Marty, reportedly jumped on the car as Mays drove away with the child inside. She ultimately died when she was thrown from the top of the vehicle. Now, the boy was found when the car was abandoned and Mr. Mays ran. Now, Mr. Mays ran. He was quickly apprehended, and he is now in custody facing 1 count of manslaughter. Once again, another tragic case that could have been prevented. I don't know the circumstances of these particular individuals, but if you have disputes, you don't go and resolve them yourself unless everyone's going to be a rational adult. If one party is not being rational, you have to go to court to get matters resolved. But you don't go and take the child. That's called kidnapping. I don't think Mr. Mays thought his day was going to end the way it did, and neither did Brittany Walker Marty, who is now gone and now has a child that basically has lost both parents. Let's take a quick recess before we progress through the rest of the docket. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. Next on the docket, who has your credit card? Well, Kevin Hart, the comedian, he does pretty well for himself. And apparently he did so well for himself that he didn't notice that his own personal shopper had spent more than $1 million on unauthorized purchases on his credit cards. The now defendant, Dylan Jason Sire, was arraigned the other day facing grand larceny and other charges in the Queens District Court in New York. Sire, 29, was charged on a 10-count indictment with grand larceny in the first and second degree, criminal possession of stolen property in the first and second degree, identity theft in the first degree, and a scheme to defraud in the first degree. All serious charges where someone faces the possibility of going to prison. That's right, for theft. $923,000 was charged to Hart's credit card, combined with $240,000 worth of jewelry and watches bought from a California jeweler, all completely unauthorized. Now, one may think, how could Kevin Hart not realize this? Well, we researched Mr. Hart, and he's worth an estimated $200 million. So $1 million is a very insignificant portion of his wealth. And guess what? He probably had people that he trusted to take care of this. I'm sure he trusted Mr. Sire, who maintained and kept those credit card numbers and used it for his own benefit. You have to be careful of people, particularly if they have your financial information. You trust, but verify. I'm telling you from personal experience, trust, but verify. Because if you just trust, they're going to take advantage of you. And finally on today's docket, our dumb criminal contestant of the day. Please meet Riley James Cushman. He's 23 years old, and he is quite the civil activist. He believed that he was protesting for civil rights by exposing his penis to oncoming traffic. When the police arrived in a Tampa suburb, Mr. Cushman's pants were down around his knees, and he was holding his penis while facing traffic in a vulgar manner. When the police did show up, Mr. Cushman pulled up his pants, walked away. When the police inquired as to what he was doing, he stated he was protesting for civil rights by showing his penis. I'm not exactly sure what civil right that Mr. Cushman thought that he was protesting in this particular case. Apparently he couldn't articulate it either. But needless to say, he was charged with exposure of his sexual organs, which is a misdemeanor and may require him to register as a sex offender if he is convicted. So, Mr. Cushman, you are a dumb criminal contestant of the day. Well, we understand political protest. We're all about it. We believe in free speech, but at least you should know what you're protesting. And as a little bonus today, this reminds me of the Free the Nipple lawsuit that we had here in Colorado. And in that particular case, the Fort Collins City Council had an ordinance on their books basically stating that women between the ages of 10 and 18 could not expose their nipples. It was found to be unconstitutional because guys could expose their nipples as well. The City Council finally, after spending several hundreds of thousands of dollars defending their ordinance, decided not to proceed to the United States Supreme Court to have them decide the case of Free the Nipple. Needless to say, once the ban was found to be unconstitutional, there was not a plethora of people exposing their nipples. The only thing that the police could report was they saw one nude sunbather who was off to herself, and one other person inquired about conducting a topless yoga class. Other than that, nothing has taken place. So I'm really not sure what Mr. Cushman was protesting, but I think it's pretty clear that you don't go around showing the bottom half, and I think that's applied to both male and female. Mr. Cushman, congratulations. You're a dumb criminal contestant of the day. Thanks for watching. We'll see you tomorrow on Crime Talk. Have a wonderful day.